All right, so I'm going to try to make these videos quick and a little bit shorter for people to understand. So this video is going to be on legal separation. This is what I filed when I found out about the fraud after I fired my attorney. So I went to court, pro sic litigant, to argue my case, and I submitted my motion, so they had all the evidence. And instead of her hearing my motion, she then made me sit outside the courtroom for an hour. She called my counsel, Chris Tillman, that had already fired. He was not retained. Notice that they admit there's two separate cases. So, first of all, Rena Hughes was not the judge on my first case. It was Kathy Hardcastle. It was switched to her. So then when I filed for legal separation, the clerk selected Rena Hughes again. So then when I went into court to tell her about the notary fraud, notice Bobby didn't even have to show up. Notice that the lawyer switched from Garrett Chase to Grayson Moulton because now Garrett Chase had to file a case with Linda Nah and he couldn't represent both clients. So how is he doing it now? Well, anyways, also notice when they say this is all about changing my name, I tell my attorney, no, this is not. This is fraud. And then listen, the court date is supposed to be the following month. Well, how did the court get changed again to the following year? So my motion was never heard. My evidence was never heard. You could hear me telling my lawyer, hey, you didn't talk about none of the fraud. And he says, hey, that's for trial. So I did everything I possibly could to get justice and to get away from Bobby Antee and to put Linda Nah in jail where she belonged. But these judges first switched my judge, then Rena Hughes ignored my motion. She allowed the legal malpractice of Chris Tillman and Grayson Moulton, and then allowed them to delay proceedings for another year while they abused me, why they extorted legal fees from me, and why they lied about everything and concealed all my evidence. So watch this video, and I'm going to show you the legal separation filing was 301 pages of evidence, and the entire story of what Linda Nah and Bobby Antee did with evidence, 65 exhibits of evidence of all of this. The exhibits I'm going to go over with you guys are going to be the ones that pertain to her fabricated orders. So you can see that 2 years before she put in that order, she had evidence that went against everything she put in. So they never had any intention on upholding the law or are honoring my rights as a victim of a crime, but had every intention on defrauding me. And the more I learned about the case and the more I learned about what they did, the more they started putting in judgments in chambers and awarding themselves millions of dollars. And I don't even know why I don't have any money. So their judgments aren't going to do anything. So watch the videos, and when you guys watch the videos and see the evidence, I'm going to ask you guys to share the video. Share the videos, sign my petition. They've already deleted one petition. So the same judges committing crimes on the bench are putting in orders to delete the evidence off social media, off YouTube, to delete my petitions off change.org. And that's as simple as it is. Judges can lie about whatever they want, put in an order for whatever they want, and whoever receives the order assumes it's valid. So I'm asking you guys, in the next 3 days, I'm going to post 3 videos, and it's going to pretty much finish telling the story of everything they've done to me. I'm going to ask you guys to please sign the petition and demand that the FBI gets involved and there's an investigation and a forced reform of the Nevada court system, because Judge Rena Hughes has a history of doing this. And had any of the federal judges stopped her, then she wouldn't have been on the bench to do this to me. And now they have labeled me a criminal. They have put in restraining orders against me when I don't even live in that state or bother anybody there. And then they've awarded the people who victimized me over $250,000 each. So their goal is now, since they can't convince everybody that I'm a scammer and I'm a liar and I've proven that, no, the fraud was committed against me, they're going to use the legal system and abuse of power to try to force me into bankruptcy. So I'm asking you guys, sign the petition. I deserve justice. Bobby Antee, Linda Nah, and Nikki Bott deserve to be in prison. And so do every single judge in the Nevada court system who has concealed these crimes. All the way up to Miranda Dew, the top chief federal judge who ignored the misconduct of all 26 judges under her and dismissed my case and allowed the abuse on me to continue. Currently, my house has not been sold. Bobby has illegally entered it. He has stolen my things, but if I can get your guys' support, we can stop the sale of my home and hold these people accountable and put them in prison where they belong. I have filed lease pendants, so there are liens and claims on my home, but in 2 years, they have held 0 court hearings. So they can't remove the liens because they won't hold a court hearing because they have no case. So I'm asking you guys all to watch the video, share, and sign the petition, and put a stop to inequality in our justice system and the abuse of power. Here you will see the register of actions from the original case filing. You can see Bobby initially avoided service, and then I filed for an injunction to ensure that he could not sell the house because it was never the agreement that it would only be in his name. And then I also filed for temporary spousal support, being that he took $26,000 of my separate money and all of the possessions of the home, and nothing was returned. You can see here that they said on 10/19/2018 that it was heard by Rena Hughes. You will see from the videos that it was not heard by Rena Hughes. It was heard by Kathy Hardcastle. Kathy Hardcastle refused my right to be heard and then allowed the case to be transferred to Rena Hughes, where she could ensure that I got no justice and that this divorce would be the most difficult process for me on earth. This is Judge Kathy Hardcastle, the judge who presided over the hearing on 10/19/18 for exclusive possession and temporary spousal support. You will see in the video, she addressed none of that, and each time I tried to talk or show her any evidence, she told me it would not be heard and it would be heard at an evidentiary hearing, a hearing that she said took place on this very same day, but it never did.
Okay, so... And that was signed at the same time you signed the gift letter?
It was signed before the last gift letter because I told him I would not sign the last gift letter until he signed the agreement because I didn't trust him or her.
All right, so he acknowledges that he owes you at least $75,000. You say he owes you $98,000.
$98,108, and I have them all right here with the proof.
All right, and so you want exclusive possession of the house? Is that what you want?
Yes, ma'am. I have no idea who my house is financed under. I can't do anything with the utilities because he put me on absolutely nothing. I can't even move out and get a new place because with the $26,000 cash I gave him, he never even paid my last month's rent.
What, so $26,000 was that? Was that in addition to the $98,000?
No, that's included in the $98,000. I gave him $26,000 cash for my savings, in which he went to the realtor and told her it was a gift, and she never got a gift letter for that amount, and let him spend that money.
Just answer my questions. So for today, what you want, pending a hearing where we can determine all of this, if necessary, you want exclusive possession of the house, which you say that you gave $98,000 for.
That's correct.
And what else do you want?
I want the brown dresser, which was community property. He removed all community property from my home. I want the $4,060.74 that I used to pay off his car because he let me sell my car with the intent that I would have one that he bought and 2 days later took it away.
Okay.
And then I would also like the ring that I purchased because I paid for both rings. And I would like him to stop coming by my home and slandering my foundation.
All right, thank you. All right, counsel.
Thank you, Your Honor. Real quick, so obviously with the exhibits we just provided, we have all the signed gift letters.
Yeah, and you know how the courts look at that on a brand new marriage. Yeah, no,
right.
It ain't gonna work. Sure.
And then if you look at exhibit number 3, Your Honor, it shows text messages between Ms. Licari and the realtor, Linda Ma, regarding the purchase of the house. I understand there's been sort of some back and forth and both the request and reply that...
It's a marriage that didn't last a year.
Right.
You acknowledge you got $98,000, or your client acknowledges you got the $98,000?
For part of the purchase of the house for them to live.
He got $98,000, right? And he took the house in his own name.
He
and
did.
It's his position, that's a gift?
Your Honor, so the reason the house was in his name had to do with the procedure for closing on the house and
The
also
financing.
the mortgage.
Right. So there's no gift.
Right.
So, the house is going to have to be sold.
And we would just ask that
She will
the
get her
equity
money
is
back.
split evenly.
After she gets her 98,000 back, she came up with the 98,000, right?
Again,
There's no 98,000. The total was
All right. So,
we have
obviously, we either need a settlement conference or an evidentiary hearing
yes, Your Honor.
to determine who put in what money and where the money went
That's correct, Your Honor.
and how much she's going to get back. We're going to spend thousands of dollars on attorney's fees, which you're probably going to have to bear the brunt of. So we can fight this out. Not even a year marriage. If there was overreaching, because parties who are married have a duty to treat each other fairly.
exactly, and there's no 98,000.
Yes, sir. So do what you need to do. Just understand at the end of the day, you might not like where you end up at. Same with you. You went into this eyes wide open, maybe a little naive, maybe you let him overreach a little bit.
No,
But-
I married him 3 weeks after my son's house.
So we will look at all that at the evidentiary hearing. But this is going to take some time, and you need to do your discovery and get your exhibits and get your documents put together. Because just because you're not represented by an attorney doesn't mean that we're going to cut you some slack.
I understand.
Okay? In the meantime, who's living in the house?
As of July 1st, Ms. Licari is in exclusive possession of the house, but Mr. Antee is still paying on the mortgage each month.
Okay. And can you afford to pay on the mortgage?
Well, our agreement was when we were married that
Can you afford to pay the mortgage?
Yes, but I've also given.
Okay. So you want to remain in the house? Is the mortgage behind now?
That was current.
Okay. So where are you working, sir?
The Vidara Hotel.
And how much are you making per year?
Approximately like 30.
Notice the pause in the video. They cut out what he said next.
All right. And all the bills are in your name.
Yes.
Okay. How quickly can we get an evidentiary hearing?
Monday at 1:30? October 22nd?
You want a hearing Monday at 1:30, October 22nd, or do you need time to do a little more discovery?
If we could have time, Your Honor, just to do a little more discovery
Okay.
and prepare. I know Mr. Molden or Mr. Van will be attending that hearing, so
So about 60 days out? Does that work?
that'll work for us, Your Honor. Yes.
What do we have? Early January? Okay. Half day, full day?
I would say probably a half day, Your Honor. And Your Honor, if January's too far out, we could also do 30 days, sometime in November.
Okay.
Well, let me look them up though, because she has nothing in January. Can I call trustee judge and just ask her?
Mm-hmm.
Wait, okay. Hey, Judge Rena.
Everything was on my base. Nothing is working on cash. Still all.
March 26th at 1:30 is the hearing.
So March 26th at 1:30 then.
March 26th at 1:30. Thank you.
So she'll continue to live in the house.
She was given the mortgage information as soon as I moved out. She said she was gonna pay, and I have text messages.
Okay,
as well.
she can make the mortgage payment.
Well,
Until
I
we
would
have the
like to
hearing.
present to the courts an agreement that was made between me and Bobby about the mortgage in the office. Because I'm still obligated to the lease of my office, and the agreement was I would pay my office and he would pay the mortgage. And my lease is not ended, so I want him to fulfill that obligation.
Just real briefly, Your Honor. So the office has to do with her businesses and Mr. Antee.
He's on the office as well.
Do not interrupt.
And we would ask that if she's going to live in the house and enjoy exclusive possession of the house, which she has been since July, that she actually pays the mortgage. So
Okay, the other option is I order the house be sold and that the proceeds be held until further order of the court to determine who gets what.
And
Unless the parties can agree as to any portion of it as to who gets it. We'll do it at the evidentiary hearing.
yeah, no, we'd be okay with the.
Well, I gave Bobby the option to quit claim my home, and he's going to make me lose money by selling it. I have somebody who's willing to quit claim it, take over the lease for me, so then I do
I'm
not
not prepared
have to
to
sell my
order
home.
that today. Either you continue to live in the house, pay the mortgage, pending further order of the court, and then when we have the evidentiary hearing to determine who's entitled to what,
Okay.
then we can divide out the proceeds accordingly.
Well, since
Or you can immediately list the house for sale, sell it, order the proceeds held, unless the parties agree upon some disbursement of some of the monies prior to that, but only by mutual agreement of the parties. So what do you want to do?
I would like to request that he pay half of the lease that he signed for on the office, since he
We'll deal with all that at the evidentiary hearing. This is just a preliminary motion.
Well, my concern is that I'm obligated to pay the fees at my office, and then he's going to throw
You can't have it
the
all.
fees on my house as well after.
Madam,
up
you
December
can't
1st.
have it all. This is a preliminary motion, short-term marriage. We will decide this at the evidentiary hearing when we've taken testimony, looked at the exhibits and the documents that are presented, determined what your rights are, who gets what, and what happens to the money.
Okay.
Marriage can be a losing proposition for both parties sometimes,
I
okay?
understand that.
So, in the meantime, though, the question is, the house is there, you're living in it. Either you pay the mortgage, continue to live there until we have the hearing in March, or we can order it listed for sale. You pay the mortgage while you're living there until it's sold, or you can move out, let him move back in, he can pay the mortgage. What do you want to do?
I will pay the mortgage on my own home.
All right. So, she'll
As far
be
as the
granted
office-
exclusive possession of the home. She'll be responsible for the mortgage. You've given her the mortgage information, sir?
No, I
She's
don't
had
have
the
any
mortgage
of it.
information since
Okay, make
January,
sure-
July
We'll give her the mortgage
1st.
information.
And the utilities.
Are all in my name.
I
All
cut
right.
the utilities
So
off
you're,
once I moved out.
do not volunteer information. Don't be arguing and talking over each other in the courtroom. So make sure, you say the utilities are in your name.
They are now, and I had to pay all the past due
I
bills.
don't care to hear all that. My question was, are the
Yes, they are.
utilities in your name?
Most of them,
I don't need to hear the rest of it. Are the utilities in
Not
your
all of
name?
them.
Which one's not in your name?
the trash, he will not give me the information, so I can't switch it. The water, I cannot switch. The gas and the electric
Okay,
are now in my
sir,
name.
if those utilities are in your name, you pay them, you present a copy of the bill to her, and you are to pay him back for any utilities that he pays for,
Okay.
pending the March.
They're all
Here it
past
is, right.
due.
So get them caught up. Get them caught up. And you'll find yourself in contempt of court. All right? All right. So you'll live in the house. You'll pay the mortgage. You'll pay the utilities that are in your name. He'll pay the utilities that are in his name. And present you a copy of the bill, and you'll pay him back for whatever utilities he pays from today forward. Past utilities, you need to get those caught up, and we'll determine that in the March hearing.
I had to pay $250
I don't, I'm not asking how much today. You presented to me and to them,
I'll bring all this.
okay? And you've got your evidentiary hearing date, conduct your discovery, comply with the procedural rules, make sure that you're complying with the procedural rules, and we'll see you back here March 26th.
What about 1:30? The spousal support, ma'am.
At this point, I'm not ordering any spousal support. It's a 6-month marriage.
But he
We
took
don't-
$98,000 of my money.
And that will be determined at the evidentiary hearing, and a determination will be made as to what portion of that you may or may not be entitled to have back and how it's going to be paid to you. All right?
Thank you, Your Honor.
All right.
Rock the record, Jeff. Yeah.
We can prepare the order.
Thank you. 573-154. Lindsay.
This is the order from the hearing on 10/19/2018. Notice in the upper right-hand corner, this order was not filed until December 18th, 2019, almost 2 months after the hearing. Also notice from the video that Kathy Hardcastle was the judge who presided over this hearing. But if you look at the order that was put in 2 months after the hearing, it was put in by Rena Hughes, where Rena Hughes forced me to live in the house, solely pay for the house, and allowed the delay of my trial for 2 years when they had clear, concise evidence of forgery and mortgage fraud. After reporting mortgage fraud to Kathy Hardcastle and submitting very clear evidence of the fraud that occurred, Kathy Hardcastle silently transferred my case to Rena Hughes. Rena Hughes is known to violate civil rights and has threatened to jail a child and has had several misconduct complaints, but is now being protected by the Attorney General, Governor Sisolak, the Nevada District Attorney's Office, and every judge concealing mortgage fraud in this matter. Rena Hughes was not my judge, and she was deliberately picked to violate my constitutional rights and allow the abuse. Here you will see the case details for the divorce matter. They have illegally sealed this case so that you cannot look it up through the Register of Actions. If you look on the upper left-hand page, you can see that the judge is now Don Thorne, not even a family court judge. This is now the 6th judge to preside over this 2-month marriage. After Kathy Hardcastle, they switched the case to Rena Hughes, and then when Rena Hughes lost her seat, the case was switched to Dee Butler, who also concealed the misconduct, recused herself, switched the case to Don Thorne, who then Ron Israel put in orders and never presided over any hearing. But you will see this from all the case details. You can see also that Bobby Antee is using the exact same lawyers as Linda Na, which is legal malpractice. When you look on the right, you can see that in June 26, 2018, I filed for divorce and also filed an injunction preventing Bobby from selling the house because he committed fraud. The injunction was granted, but they did nothing about the fraud. I then, in July 23, 2018, filed for annulment, and Bobby Antee and his counsel responded, and I also filed a response to them. In that response, I let the judge know about the fraud, about the forgery, and about the misconduct of Bobby's attorneys as they were also representing Linda Na. All of my motions were ignored because if you watch the video in 10/19, she heard none of it. But if you look at the case details, they say they heard all of it. Notice here on 10/3 that Bobby's counsel requests for a motion or counter motion without an oral argument. Therefore, they already knew about the fraud. But by making sure I was not able to argue my case, they were allowed to conceal it again. And then you can see on the right, on 1019, where Kathy Hardcastle said she heard all of this, all of the motions. So the motion for attorney fees, a motion for spousal support, my opposition. And then she says there was an evidentiary hearing on the 19th and also a case management conference. But if you watch the video, you can clearly hear her tell me several times that she was not going to hear anything of the evidence that I had in front of me on the table, and that I would have to wait for the evidentiary hearing that she was actually holding that day. So she knowingly concealed mortgage fraud and then transferred my case to Rena Hughes because she didn't want to continue the fraud, and allowed Rena Hughes to continue the fraud and the abuse for 2.5 years. They didn't even put in an order for the exclusive possession until 2 months after that hearing, after I filed for another injunction trying to protect myself. Notice on the right, it says there was a notice of entry of order on 1024. On 1024, there was no entry of order except for to withdraw my attorney from record. So therefore, Kathy Hardcastle never put in an order after the hearing. She simply allowed the case to be transferred until December of 2019, when I filed another complaint for separate maintenance trying to annul the marriage again. Rena Hughes then ignored the motion and stipulated to continue the trial again, and then allowed Jennings and Fulton to take over the case and again conceal mortgage fraud, ignore the legal malpractice of Shumway Van. After watching the video, you can clearly see that she did not do a case management conference. She did not do an evidentiary hearing, but it's noted here that she did on her case details. If you look on the right, you'll see that on a week later, Rena Hughes then took over in her chambers and vacated my motion and allowed the legal malpractice to continue and the abuse and the concealment of fraud. Here on October 19th, 2018, notice Bobby being represented by Garrett Chase of Shumway Van. Once I found out of the fraud, I then reported Linda Nah, the realtor, the only person I had any communications with, to Galvar, the ethics board. You can see here that she was represented by Garrett Chase from Shumway Van, the very same lawyer you just saw representing Bobby in the trial, which is legal malpractice. This legal malpractice has continued now for 4 years without Nevada State Bar doing anything to stop it. You can clearly see that in December of 2018, I had already let Chris Tillman go, and I was now representing myself, in which I filed a separate case into a separate department to have legal separation. This was also filed into the divorce. Legal separation filing, 301 pages, 65 exhibits of evidence of damage to the home, emails, stress caused to me, the abuse Bobby made me endure during the time I was there, police reports, proof that he had open child support. All of this evidence was given to the courts into both cases in December of 2018. The lies from my sister, social media slander, text messages, emails from Bobby's, him trying to cancel my lease at my foundation, him admitting to not knowing I wasn't on the title, slandering me on social media, damage to my storage, damage to my property, that I was physically breaking down. All of this information was given to the courts in December of 2018. Exhibit 59 of the legal separation filing showed that Nikki Bott was the escrow agent and the notary. you can then see on the next page, I provided them with proof there that Nikki Sakakis was the notary and the escrow agent. So from 2018, from the legal separation filings, the courts had very clear information of notary fraud and put me through 3 more years of abuse. After I informed Kathy Hardcastle of clear fraud in the October hearing, she then put in no orders and then allowed my case to be transferred to Judge Rena Hughes. Rena Hughes then put in an order from a case she did not preside over and consolidated 2 cases into her court. She never heard the legal separation. She never heard the annulment. She then consolidated it and then allowed them to move my trial from March of 2019 to February of 2020 to try to force me into settling.
We have 2 case numbers, D581756 and D573154. Your appearances, please.
Your Honor, Christopher Tillman, 5150. I represent plaintiff Lindsay Antee.
Thank you.
Good morning, Your Honor. Grayson Moulton, bar number 14587 on behalf of Bobby Antee, defendant.
Thank you. This is the time set for the defendant's motion to dismiss or to consolidate, and then I have an opposition and a counter motion for attorney's fees.
Correct, Your Honor. Simply put, legal separation and divorce are they're contradictory to each other in their end goals. Plaintiff has filed a legal separation. She filed it mere days after getting the order back, denying her a lot of the relief that she sought in the temporary orders motion in the divorce case. She still requests the same thing. She requests the house. She requests the wedding ring. This is just an example of being vexatious and being over litigious and not allowing the course to proceed as it should. We have a trial set for the end of March, but instead we're having to answer frivolous motions, and that's why we're asking for attorney's fees to be awarded.
Okay. Mr. Tillman?
And Your Honor, when you look at 760, the vexatious filings, you have to point squarely at the defendant, and here's why. I'm the attorney on the underlying action. My client, yes, she filed an action on her own, but immediately upon me learning of the filing, I sent the letter, that's Exhibit 1, that says, hey, send me a stick to dismiss it. I had a conversation with her after I learned of it. She didn't understand that she couldn't change her name in a divorce and a legal separation, so that was one or the other. So we had a conversation, and that's when I sent the letter. The letter went out January 25th. The response was, well, pay some fees. And I was fairly incredulous about it. Why should I pay or have my client pay fees when I'm the attorney of record? You didn't even do a 511 or pick up the horn and call me and say, Chris, your client did. That's what people would do if you're not being vexatious.
And you're retained?
I'm retained. We're set for trial. There's discovery propounded. There's letters going back and forth. We've talked about possible settlement. I don't know why a motion was filed without a 511 letter, because that's what I would do. I'd say, Grayson, your client did something, she shouldn't have done or he shouldn't have done. Let's combine it. Let's dismiss it. Let's, whatever. So that's why we're here. 760 is why we're here.
Your Honor, I can't speak to what the nature of the retainer agreement is between the plaintiff and her attorney. I know that when I sign retainer agreements with my clients, they are very specific as to the terms under which I am representing them. We responded to the legal separation, filed a motion to dismiss, and then we alerted. She filed it in proper person, and then we alerted her counsel in the divorce case as to what was going on. But we still were under an obligation. I was still under an obligation to my client to file a motion to dismiss.
He said you didn't.
No, I didn't hear. I got to make sure I'm clear with what he said. The first I learned of my client filing this was Grayson's motion to dismiss. That's the first I heard of it. Okay? That's when I sent the letter on the 25th of January saying, Grayson, we'll dismiss it. I'll send a step. I'll prepare it. So, again, I had a conversation with Lindsay and said, that's a no, don't do that. But the first I learned of it was the motion. Had I gotten a 511 letter, I would have said, of course, Gracie, let's dismiss this.
Right. Okay. And you couldn't work with Mr. Tillman?
Your Honor, I requested that for the time that we had to put into the motion to dismiss, I asked that my client be compensated for the time he's had to put through. He's already looking at a case that appears to be going to trial. He's already looking at fees racking up. He was forced to respond here. We requested that
But
fees be
being
given for that
forced to
purpose.
respond, I mean, if Mr. Tillman's client did something without his knowledge, you weren't forced to respond if you had just called him and tell him, your client's done something silly. Do you know this? Do you know about it?
I was unaware as to whether he was representing her in this case or what the nature of the representation was.
Well, I find that your motion was unnecessary. He's willing to stipulate to dismiss. So, Mr. Tillman, if you'd prepare that stipulation, please. We're going forward on the original case. Ma'am, you need to communicate with your attorney. So Madam Clerk, the 581756, Mr. Tillman's going to prepare a stipulation to dismiss that one. We're still going forward on 573154, and there's a trial set for March 26th, and that stands.
That's correct. And, Your Honor, is there, March 26th, is that the earliest date you have? I mean, I don't know that.
Yes.
Yeah, I mean, Lindsay's asking, can we do it quicker? She wants to be divorced quicker.
Actually, I'm not even going to Bishop, and I have trials set every day.
So the answer is no. Okay.
Every day, even my admin days, I have trials.
Be a trial. Very good. Okay, so the 3/26 date stands,
That's all I have.
and we're not, and no fees either way.
No.
And I will prepare the stip for Gracie to sign.
Thank you, Your Honor.
Please
Thank
do
you, Your
so
Honor.
within a week, Mr. Tillman.
We'll have it to him by the end of this week.
Thank you.
All right. Thank you, Your Honor.
Here you will find the order entered in by Rena Hughes on a hearing she'd never presided over. The hearing was in October, but notice in the upper right-hand corner that this order did not come out until December of 2018, 2 months after the hearing, and then was put in by a judge that did not preside over the hearing, and then ordered me to live in the house, ordered me to repay Bobby any money that he paid towards the house, and then ordered me to solely pay for it going forward, pending the hearing in March of 2019. I paid all utilities, the deposit, and all rental payments. There was never a hearing in March of 2019. They moved the trial to February of 2020, in which I made $37,000 in mortgage payments, put $62,000 down on the house without my knowledge, and now the entire house and all proceeds are being awarded to Bobby Antee by Rena Hughes. Again, notice this is a different judge, Kathy Hardcastle, the original judge assigned to the case. On 10/19/18, she heard the hearing that I represented myself, refused my right to be heard, and then Rena Hughes took over the case, put in the order on a hearing she did not preside over, and the abuse against me continued. After the 10/18 hearing, they then switched Bobby Antee's lawyer to Grayson Moulton, another attorney at Shumway Van Law Firm, in which he took over the case for the next 2 years, where they tried to litigate the home as community property, knowing that Bobby, Linda Na, and Nikki Bott all committed fraud and used dirty judges and lawyers to do this. All right, so thanks for watching the videos. So if you guys watched it, you saw the legal malpractice, you saw the switching of the judges, you saw the refusal of letting me speak every time I went in, and then from that point, there wasn't anything until the trial. So I have suffered this abuse for 5 years as a victim of a crime, so that all the government workers, all the judges, the police officers can all be protected. They have now illegally entered my home. They have illegally listed my house on the market and are attempting to sell the house and all the proceeds from the house will go to Bobby Antee and his lawyers for committing a crime against me. So I'm asking you guys to join me in demanding that the FBI make an arrest of Judge Rena Hughes and ensure that Bobby Antee is held accountable for the crimes that he committed. Nobody should put somebody through the abuse that I've been put through for 5 years and then be awarded with your tax debt paid off, all your debts paid off, a possession of a house, your legal fees paid, and you were the one that committed the crime. This man has done nothing but try to destroy my foundation, my son's legacy, and slander my character to protect himself from the crimes that he committed against me with the help of his buddy Linda Naw, the realtor. So I'm asking you guys, please sign the petition at www.change.org, arrest Rena Hughes, and ensure that this judge is held accountable for what she's done. The other 26 judges who are also committing fraud and concealing the misconduct of Rena Hughes have now started putting in orders to ask Facebook, YouTube, change.org to delete all the information and petitions on their own misconduct. And they're doing this. So change.org deleted my last petition, 5,000 signatures, based on an order put in by one of the judges committing the crimes. So I have started a new petition, and I will continue to replace the petition until I get 10,000 signatures, which will force Congress and the FBI to investigate the judicial system of Nevada. So please find my petition on change.org. You can find it in my bio on Instagram and also on my post on YouTube and Facebook. And hopefully my case and the abuse that I've suffered will bring reform to Nevada and the justice system all over the United States. But if we can get one judge, Rena Hughes, off of the streets, then we can ensure that no other family will be hurt by this woman.